Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Saturday, April 5th, 2025. We are on voting list number 24. And we're going to start off with House Bill 1378. That's Jamie as counsel.
House Bill 1378 alters provisions of law relating to the award of non-economic damages in an action for child sexual abuse. The bill alters caps under the Local Tort Claims Act, the State Tort Claims Act, and provisions applicable to county or local boards of education, and makes corresponding changes. The bill also places limits on the award of attorney's fees as specified in the bill.
All right, questions from the committee? Any further discussion? Senator West.
I think we should put on the record council's analysis of the occurrence issue that this bill attempts to deal with. As we learned in the Supreme Court decision dealing with the bill we passed several years ago, legislative history is extremely important. And irrespective of the actual language used in the bill, legislative history could be used to suggest to the court that the bill should be interpreted differently than the plain language used in the bill. So I think legislative history should be explained here to us.
Sure, yes.
I think that need to have clarified in particular is that we are striking out language an alleged incident or incidents and substituting a claim or claims. I think that should be the
So that's correct.
Yeah.
So the current Tort Claims Act, which is the language that was ported into the statute, it says incident or occurrence. We've now redrafted that to say claim or claims, and the intent there is to clarify the intent of the General Assembly to so that it's basically one claimant. So the example would be if there were an incident of abuse that occurred at a facility. If that abuse occurred over a course of time, that, and just to be clear, that this new language is to clarify the intent of the General Assembly to make that that's one claim, and that's one for the claimant. Okay, that's one claimant for all those incidents.
If I could, let me make it even more clear. If there were a youth in a facility and that youth had unwillingly a sexual encounter with a particular guard on a regular basis, say every Friday afternoon, under the current law, there would be an argument that that was separate occurrences. And under this bill, even despite the fact there may have been 40 such encounters, the person who was abused would only be entitled to a single recovery. Am I correct in that?
So that is the intent of the new language, and it's to clarify the intent of what the current language is. And so the short answer is yes. And I know there is a recent Supreme Court case that has opined on that type of a fact pattern. But this appellate court, it's an appellate court case, the Young case, the state of Maryland versus Michael Young. So, but the answer is yes. Counsel, is that your interpretation?
Would effectively be, and just to state it somewhat differently, yes, it'd be on a per claimant basis.
I think it's also, just to make the record clear also, having just read the Young case, that focuses in on this typical language that had been in the tort claims about an incident or incidents, which generally is the fact pattern underlying the claim. I think the real significance of taking that particular language out, and I think also making the Young case not relevant to our current circumstances, is that we've substituted claim or claims, which have legal significance in how you plead a case in court, not which would include the facts, but is different because you're creating, a breach of this or a tort of that, for which fact patterns which do rely on fact patterns but are separate and different. So we are focusing far more on how the case will be pled than an individual incident in which that underlies that pleading or claim. So I think that is the clarifying also that we need to have in this discussion.
All right, the motion is for favorable. It's been, we do need to adopt the amendment, the clarifying amendment. Yeah.
And I want to flag for the committee,
Clarifying amendment, yeah.
there's a technical amendment that was needed as the result of, told a printing error on page 7. In line 5, after 2025, comma, in order to conform with the rest of the bill, we need to add the language that would have been barred by a time limitation before October 1st, 2023, comma. The other provisions of the bill had that amended into them, and to conform, that language would be needed to be added to page 7.
This ensures that the claims going forward are still under the 895.
Right, so this would change the applicability, so that $400,000 cap with the amended language would apply only to those previously revived previously stale claims that were filed on or after June 1st, 2025, instead of all claims filed on or after June 1st, 2025.
Senator West.
Thank you, Mr. Chair. I would like to propose in conception an amendment. Actually, I've got the text of it.
Well, actually, let's just do this real quickly. I want to adopt this
do this
amendment
one
first.
first, yeah.
Can we, motions to adopt the clarifying amendment? Second. Is everyone okay being recorded in front of that? All right, great. Senator West.
Thank you. So after the testimony of Chair Clippinger yesterday, and the advocates and the plaintiffs' attorneys, I did some elementary calculus. And if we have 5,500 claims filed by June 1st, which they predicted would happen, and each was for $890,000, we're talking about a total liability to the state of $4,895,000, which is a lot of money. The 20% attorney's fees in that situation would come to $980 million for the attorneys. So this proposed amendment would provide, I'll just read the first part of it, you get the gist from this. In any action for damages filed arising out of a claim or claims of sexual abuse that occurred while the claimant was a minor, there shall be a Child Victims Services and Prevention Fund surcharge on attorney's fees. The surcharge shall be 20% of fees collected and be submitted to the administrative office of the courts within so many days. It goes on, but you get the gist of it. So instead of the attorneys receiving $980 million, up to $980 million, they would receive 80% of that, and the remaining 20% of that, instead of going to the attorneys, would go into a fund to pay for victims, child victim services and prevention. That's the gist of the amendment.
I'll just say two things. Well, I mean, so the bill applies for that 20 to 25% cap on attorney's fees for both suits brought against the state and against private entities under this bill.
No, actually, this fee would only apply in the event of the 20% fees. In other words, if the cases were settled ahead of time, and I gather there are negotiations ongoing, they could be settled quickly without the need for attorneys to go to court.
Just making clear that cap now that this bill puts in applies both to suits against public entities and private entities.
Correct.
So, which is a departure from where the default position is now. Those caps only apply to suits against the public entities under the current law. I like the idea of setting up the fund. I just think that it's a significant policy change and shift that necessitates further review. And I like the idea, but I would ask to either withdraw or reject the amendment, because I don't think that we have the time at this late hour to do that type of research to understand how that works. And with the caps also applying to the private side of the house at this moment, I'm worried also about access issues for cases, you know, with the caps as they are. And so, and with those two things in conjunction with each other, I'd ask that we just take a look at that at a later period.
Well, let me ask this of counsel. If this amendment were to be withdrawn today, and we were to pass the bill as written today, so it went into effect this June 1st, would it be possible for us to come back next year and introduce a piece of legislation which would do exactly what this amendment purports to do, which is take 20% of the attorney's fees out and put them into a fund to fund child victim services?
So so I understand the question, Senator, would it be possible for legislation passed next year to place a fee moving forward on attorney's fees recovered?
In these cases.
Not attorney's fees that have already been paid, but attorney's fees yet to be
paid.
recovered.
Right.
I can't think of any reason why there would be a legal or constitutional issue with placing a fee prospectively.
I can't, frankly, I can't either, because the Attorney General's opinion, which we received dated March 17th, does deal with attorney's fees and indicates that until they're actually earned, we can modify the attorney's fees. And that would not be unconstitutional. Okay. That being the case, then I will withdraw the amendment and we'll revisit this issue next year.
That's why I was going to speak to the amendment, but you're on.
Now the bill's before you as amended. There's a motion for a favorable. With the amendment, it's been seconded. Do we need a roll call?
I just want to explain my vote.
All right. All right, let's, let me just see what the vote count is really quickly. So you're down. And so are you down? Are you down?
No, I'm
Okay. What is your vote?
voting yes.
Yeah.
I'm going to vote yes.
Okay. So we've got one down. All right, excellent. All right. Go ahead. Speak on it.
Yeah, I'm, for whatever reason, I'm really sorry that we are here to make this kind of decision this late. Generally, I am always with the victims on an issue like this, and because of where the sponsor is, that has, because he's fine with it, I don't think I'm going to hold my nose and vote for it. Generally, that's not what I do. I think the victims come first no matter what, whether it's a fiscal issue, something that needs to be worked out. So I'm just not comfortable with this at all. But it seems like if we don't, all the wheels come off. And we've got to go back to, at least legislatively, to the beginning of this again, so.
I couldn't agree with you more, Senator. Thank you for your reflection. House Bill 1378 with the amendment passes 10-1. Okay. Yeah. We're now going to move on to concur, not concurs. We'll start with Josh.
So Senate Bill 181, as passed by the Senate, the bill alters provisions related to medical and geriatric parole. As amended by the House, the bill is nearly identical to House Bill 1123 as passed by the Senate. However, there is one small difference between the bills. In provisions related to requiring or allowing the Parole Commission to conduct risk assessments on individuals, the Senate bill makes a reference to the Parole Commission being authorized to conduct risk assessments on anybody who is eligible for parole generally. The House bill makes a reference to the Parole Commission being authorized to conduct risk assessments on individuals who are specifically eligible for geriatric parole. So my understanding is that the Senate sponsor would prefer the House version. So in this case, that would require the committee to vote not to concur and to make the change to the Senate bill in conference.
So does this risk assessment is not mandatory, it is optional on the part of the Parole Commission?
Correct.
Okay, thank you.
So the way that the bills kind of ended up was they created this regime where the Parole Commission would be required to conduct risk assessments for certain individuals, and then the language would be that the Parole Commission may conduct risk assessments for other individuals. So one version of the bill said they may conduct risk assessments for individuals generally eligible for parole. Another version said they may conduct risk assessments for individuals eligible for geriatric parole. And my understanding is the Senate sponsor would prefer that more limited authorization that would apply just to geriatric parole. And so the Senate bill has the broader one. So if you wanted to go in that direction, the motion would be not to concur and make the change to the Senate bill in conference.
Just to clarify, Josh. The bill we're talking about is medical and geriatric. So what happens to medical parole?
Medical parole, the two bills are currently identical.
Which is is there a risk assessment or not?
So under one version of the bill, the commission would be authorized to conduct risk assessments of anyone eligible for parole. So potentially, yes. But currently, there is no law on risk assessments for medical parole.
That is very confusing answer. So they do have to do risk assessments generally?
Currently, there's nothing in the law about risk. It's purely a matter of policy from the Parole Commission.
Oh, I see.
The bill brings it into the statute and says, right, for certain individuals who are eligible for geriatric based on their convictions and their sentence, it would now, going forward, be required. And then for other individuals, it's a may, but who is covered by that may is where the difference between the two bills is currently.
So the may is
All right,
medical?
So just
I'm
this
so
rule, all right.
There's got to be a chart.
No, it's simpler than that. The House bill says, so the default position right now is that they can do these risk assessments, but they do not have to, okay?
Okay.
The Senate bill says do it for geriatric, but no one else, mandatory.
Got it.
The House bill applied that risk assessment requirement more broadly.
So what the Senate did with the House when we had it was say that may is just for individuals eligible for geriatric parole. The House, when they did the Senate bill and sent it over, they said the may is for everyone eligible for parole generally. So it's a little bit confusing because the bills they were both amended in the opposite House, but
I read the bill originally that it was mandatory that you do a risk assessment for geriatric parole. Was I misunderstanding the Senate bill originally? I didn't understand that.
yeah, the original, so this is further confusing by the fact that they were not actually crossfiles in the beginning. So the Senate bill, as it was originally drafted, did not have anything about risk assessments. And as passed by the Senate, it also didn't. The House amended the Senate bill to have these provisions, which originated in the House bill. They put them onto the Senate bill, and they ended up being slightly different than what we did with the House bill.
I'll be darned. Okay. All right, I still don't understand what the position of the bills are, but I do understand the issue. Thank you.
So the Senate bill has more limited language on the risk assessments. Is that correct? Put it that way?
So the Senate bill as actually the broader language. The House put the broader language on the Senate bill and sent
I
it
see.
back here. We put the more narrow language on the House bill and sent it back to them.
Okay.
So the Senate posture was more limited to the geriatric. And that's the posture that we're going to move it back into now. By
You
then,
have to do it in Congress.
so we'll have to fix it in conference. That was the motion. Senator West.
Well, is our motion, it's still confusing, is our motion consistent with giving the parole board discretion in all cases whether to do a risk assessment?
No, it would, presuming, I think you go the way that the Senate sponsor wants, it would be that more narrow authorization to act on the risk assessments.
What does that mean? What's
Only
more
to
narrow?
geriatric, meaning it would only apply to geriatric.
And it's a may or a shall?
It's a may.
It's a may.
Yes.
Okay, so long as it's a may, the Parole Commission has an enormous amount of work. I don't want to add to their work unnecessarily, so
Which
that's
is the reason to more limited to geriatric, which I believe is also, I think, I don't want to speak for any other, I know that that's the Senate sponsor's position. I don't want to speak for anyone in the House, but I've
Fine.
spoken to the Senate
Okay.
sponsor.
Okay, so, yeah.
So we're doing may instead of shall, and not because we don't want to overburden people with doing their job. Just want to be clear on that.
Because otherwise it would apply to all the other cases.
So these people that are appointees that get over $100,000 each are having a hard time. I'm having a hard time with wrapping my brain around having people do their job, and why we wouldn't want them to have at least some say in this. So, yeah, thank you.
All right, so there was a motion to not concur. It's been seconded. Is everyone okay with the not concur? It's going to go to conference?
Who do you want to be on the conference committee?
All right.
Who do you want to chair?
So this is Senate Bill 381. As passed by the Senate, the bill creates procedures for the retention, sharing, and destruction of recorded images produced by automated enforcement systems. The House amendments simply clarify that those recorded images may be retained for the purpose of administering and processing citations. I think it was, as far as I'm aware, that was always the intent, but the House had some concerns that maybe there was additional language needed, so that's what they amended in it. Yeah.
All right, it's been a motion to concur. It's been seconded. Is everyone okay with the concurrence? These are concur, not concurs.
Next is Senate Bill 608. So as passed by the Senate, the bill alters procedures. Yes, sorry, another concur, not concur. Senate Bill 608. So as passed by the Senate, the bill alters procedures relating to the issuance of a certification that a non-citizen victim of crime has been helpful in the investigation or prosecution of the crime. The House amendments generally struck the changes to the bill that were made by the Senate, including alterations to the timeframes by which a certifying entity is required to approve or decline a certification.
A lot of thoughtful work went into that. I'll say not concur. Second, is everyone okay being recorded in the affirmative? All right,
Who do you want to be on the conference committee?
I'll be on that one.
Chair it.
Yeah, and then
So the next concur, not concur is Senate Bill 811. As passed by the Senate, the bill extends the task force on the creation of a division of returning citizens and expanded reentry services. The House amendment struck an amendment to the bill that was made by the Senate, which changed the exact deadline for the commission to submit its final report. The bill as drafted, it was October. The Senate made that a December. The House reverted it back to October.
all right, so there's a motion to concur. It's been seconded. Is everyone okay being recorded in the affirmative? Yes.
This is also for concur, not concur. Senate Bill 896 is Senator Love's pet policy disclosure for landlords of residential real property. The House amendments would just conform it to its House cross-file that passed the Senate.
So the motion to concur has been seconded. Is everyone okay being recorded in the affirmative? All right. Is that it?
That's it.
Are we going to go on to House Bill 681?
House Bill 681 generally exempts an obligor whose individual income for the current year is at or below 250% of the federal guidelines from provisions requiring the MVA to suspend their license or privilege to drive if they are out of compliance with a child support order and certain other specified conditions are met. However, this would not apply if the obligor has been judicially determined to be voluntarily impoverished. And additionally, the bill extends from 60 to 120 days, the period during which the holder of a non-commercial driver's license must be out of compliance with a child support order before that notice to MVA is sent to begin the process of suspending the obligor's license.
So motion for favorable has been seconded. Is everyone okay being recorded in the affirmative? All right, House Bill 681 passes unanimously.
Actually,
We've got one recede, not recede. Go ahead.
For receive, not receive, House Bill 292 is requiring certain funds for certain reserve accounts to be deposited and requiring a plethora of other changes to reserve accounts for common ownership communities, which are cooperative housing corporations, condominiums, and homeowners associations. The House is in favor of the committee amendments, but wants to reject the two floor amendments that were put on to the bill. So the floor amendments, one was to make it so that it authorizes the governing body of a common ownership community to amend a reserve study or update a reserve study with a quote from certain licensed professionals. And the other one was about prohibiting the governing body of a condominium or homeowners association from imposing certain fines, costs, fees for taking certain actions. The committee amendment was just allowing them to borrow from the reserve account and pay it back. Okay.
Fight, not recede.
Who do you want to be on the conference committee?
Let's do. We're at House Bill 1371.
House Bill 1371 authorizes the MVA to enter into an agreement to facilitate the issuance, use, and verification of electronic credentials through a National Association of Motor Vehicle Agencies. Just for some context, the current statute already authorizes them to do so for state agencies, agencies of other states, and the United States. The bill also authorizes an individual who will operate a rented vehicle to use such an electronic credential instead of a physical driver's license to rent the vehicle.
Thank you. There was a question that came up during the hearing. I want to confirm this with counsel, but there was a lack of clarity about whether this is eligible for things that are non-Real ID compliant. Maryland, as a policy choice, has provided the option for non-Real ID compliant driver's licenses and other non-Real ID compliant IDs. This question came up during the hearing. The advice that I received after the hearing is that non-Real ID compliant IDs are not eligible for this technology. I want to understand if that's your understanding as well.
So I don't see anything in the bill that specifies that. It may be that the programs that exist are all they have all voluntarily chosen to only issue Real ID compliant credentials. There is nothing, I don't believe there's anything in the bill that speaks directly to that.
I'm going to go on faith here, go with the advice that I was provided, but yeah, if we could find out after this moves to the floor, but so I'm comfortable with it, but we might want to just confirm that.
All right, motions for favorable. So, can I get a second?
Second.
All right. Is everyone okay being recorded in the affirmative? All right, House Bill 1371 passes unanimously. All right, now move on to John, you ready for House Bill 1367?
House Bill 1367 establishes a civil penalty of up to $50,000 for the falsification of information submitted in a verified report of the result of lead-contaminated dust testing or visual inspection provided by the Maryland Department of the Environment.
All right, motions for favorable. Is there a second? All right.
Yes.
John, this one's yours, right? So my question is, is the person the one who actually is taking the test or the one who is actually analyzing the test? Those are two separate people. Or does it apply to both?
So I think, I don't think I'm understanding your question.
So you've got an inspector that comes and does the testing themselves, and then they take those swipes and they send it off to a testing company. So who are we targeting for falsifying information? The one who took the test or the person who is actually analyzing the swipes? Or both?
So it's the person who performs the test,
Performs the test, okay.
who submits the report. That's what this is
But
targeting.
there's a difference between, okay, I think it, okay, we're at where we need to be. There's a difference between someone submitting the report, I think that's the demarcation, so, thank you. I don't need an answer, so, I just got my own issues with it, so, doesn't need to be. I'm gonna be down for it. Yeah.
So it passes 10 to 1. We'll now move on to House Bill 1440.
Here's a little bit of background.
House Bill 1440 requires a circuit courthouse that is constructed or undergoes a major renovation project on or after October 1st, 2025 to maintain on its premises a private lactation room that may be used by employees of the court and members of the public to nurse and express breast milk. The bill also authorizes a jury judge or jury commissioner to excuse from jury service an individual who is breastfeeding mother or has legal custody of and is personally responsible for a child younger than the age of 3 requiring continuous care by the individual during normal court hours. By December 31st, 2025, and annually thereafter, the judiciary must collect and report certain information to the General Assembly regarding jury duty excusals.
The court's fine with it as well. They're great. So it's motion for a favorable. It's been seconded. Is everyone okay being recorded in the Senator Folden?
So is this, and I'm asking because I don't know, so is this is this something that we do in every government building now, is provide lactation rooms for general members of the public?
I don't know the information about other.
Because the way this is looking, it will impose a mandate on local government, again, to accommodate every county, every circuit courthouses. It's just, any renovation, new construction.
Is it significant renovation?
Major
Because usually
renovation.
it's major.
It's
right?
major.
Major would trigger it, right?
All right,
They're not trying to retrofit.
Okay.
I agree with you.
all
They're
right.
not trying to retrofit.
They're not doing retrofit. Okay,
Yeah.
thanks.
It's just
So House Bill 1076 passes unanimously. Senator West.
I do have a question. Is there anything in this,
1440, my apologies.
is there anything in this bill that that would prevent the changing room from also doing double duty as the lactation room? In other words, does the room have to be singularly dedicated to lactation, or could it be used for other purposes in the bill?
So there is a list of things that the lactation room has to include if you could do that in an existing room. So you have to have a chair with a table, an electrical outlet nearby to accommodate placement of the breast pump, a door that may be locked from the inside, a sink, and a refrigerator.
Okay, but there's nothing in the bill that says that it has to be solely dedicated to lactation. It could, under the bill, it could be used for other purposes.
I believe so. I don't think there's
Okay.
anything that says it
Fine.
has to be
Thank you.
solely.
All right, last bill today. So House Bill 1076.
Again, it's really putting it on. Okay. House Bill 1076 requires a landlord to provide certain notice before entering a leased premises, subject to a certain exception. The bill excludes additional provisions in regard to a landlord's entry and authorizes the tenant to seek injunctive relief or damages for a landlord's violation of the bill's provisions.
Discussion. Senator West moves favorable. Senator Love seconds. We're on 1076, House Bill 1076. Folden's down, McKay's down. Is everyone else okay being recorded in the affirmative? All right, House Bill 1076 passes what, 9-2? Yep. All right, that's it. We got to get back to the floor before they get to third readers.